Okay, the day of today, I'm going to expose one of the regimes that we study in class that I think it's very important and personally is my favorite. So we're going to speak, I'm going to expose about international criminal law. My name is Nicolás POSSO, and this is for the final exam of regimes of international law. Summary. Basically, this video will make a walkthrough of what is international criminal law at a glance and in a general way. We will first see what is international criminal law, then we will see sources, then the structure of a crime, a brief history of international criminal law, a problem with the Nuremberg trials, their jurisdiction, International Criminal Court, and some final thoughts. Okay, let's get to it. What is international criminal law? Basically, we can narrow it down to three definitions: the general one, the International Criminal Court, and the doctrine, what it tells us. So, general. Basically, international criminal law is a branch of public international law that regulates the behavior of states, individuals, and organizations in the matter of international crimes. The International Criminal Court defines international criminal law as the mechanism that controls and regulates the commission of crimes such as genocide, war crimes, crimes against humanity, and crime of aggression. The doctrine that Cryer, Freeman, and Robinson stated that international criminal law, as using this book as the book that we use in class as a guide, but also the one that I use as a complementary use for information, and they find that encompasses not only the law concerning genocide, crimes against humanity, war crimes, and aggression, but also the principles and procedure governing the international investigation and prosecution of these crimes. Okay, if we see that international criminal law works not only as applicable law, but also as procedure law, because it studies some general principles and how these prosecutions are going to be established on our country, on the sovereignty of countries and nations. Basically, it's a set of rules to protect the values of international order. What is international order? Well, as we can analyze, international order are basically world peace and making the world more stable, as established in Article 1 of the UN Charter. The ICC statute uses the term the most serious crimes of concern to international community as a whole, almost as a definition of the core crimes, and recognizes that such crimes are threatening the peace, security, and well-being of the world. As stated before, this is a quote directly from Cryer, Freeman, and Robinson from their book. It's basically international criminal law is a response to conducts that are infamous and dangerous for the development of the international community. Also, they pose a threat to the UN Charter and international law stability, as stated before. Complementarity. Basically, it's the binding principle of international law. We need to establish that Article 4 of the UN Charter establishes that every state has its own sovereignty, they can manage their own rules, and they cannot go against the international community. So this means that international criminal law cannot operate as an imposing legal instrument. National criminal law and international criminal law must work together, as it can be seen in some codifications. One of them is Article 101 of the Criminal Code of Colombia that talks about genocide, and it's exactly the same definition that it puts on that is established in the Rome Statute. However, in Colombia, they like to be creative, so they added one more passive subject victim that are political members, as happened with the UP massacre in the 1980s. Sources: treaty law, basically the Statute of Rome, general principles of law such as ne bis in idem, nullum crimen sine lege, nullum pena sine iure, and customary international law. Basically, we need to remind ourselves what is the structure of a crime. First is the actus reus. It refers to the act committed by the individual. Then is the mens rea, the mental state of the subject in the act. The proximate causation, the link between the act and the result. If you are a law student and you have seen the criminal law, all these elements must be present to establish a criminal conduct. For example, genocide. Background and historical application approach to international criminal law. There have been a lot of debate in the doctrine. However, I think the first important historical event, is the Nuremberg Tribunal and International Military Tribunal. These were tribunals after World War II to judicialize the Axis members and that committed crimes such as genocide, participating in the camps of extermination, concentration camps, etc. Some legal experts say that this violated the nullum crimen sine lege, because some of these crimes, such as genocide, didn't exist before the Nuremberg tribunals. So some of the Nazi arguments were that they were just following orders and they cannot be imputed with new laws. So it's a really interesting question. However, we need to establish if this principle of law is more important than to bring to justice some of these atrocious acts. Other famous tribunals, that was the Tribunal for the former Yugoslavia, and it was for the war in the Balkans, that was in 1990s, and the tribunal lasted from 1983 to 2017. It was really interesting because it provided victims an opportunity to voice the horrors they witnessed and experienced, not only centering on the criminal, but also on the victim. That is really important when you're developing a policy for a criminal policy, for example. This was the tribunal, the location. And the other one, very famous one, is the Rwanda Tribunal. It was, again, another genocide. It was after the immediate aftermath of the Rwandan genocide, and it closed in 2015, I'm so sorry. And it was established through a resolution of the United Nations Security Council. Here they go. The ICC. The International Criminal Court investigates and, where warranted, tries individuals charged with the grievous crimes of concern to international community. Basically, genocide, war crimes, crimes against humanity, and the crimes of aggression. Key features. Trials are fair. Trials are fair, prosecution is independent, defendant rights are upheld, victim voices are heard, participating witnesses are protected, two-way dialogue, a direct approach to the communities, affecting making them a part of the judicial process. These are the binding principles of the International Criminal Court, and they're really important. The jurisdiction. Basically, the court is a court. It should be a permanent institution and should have the power to exercise jurisdiction over persons for the most serious crimes of international concern, as referred to in this statute, and shall be complementary to national criminal jurisdictions. Here, as I said before, the nebis in idem, the applicable law, or the laws that can be used, the elements of a crime, jurisdiction, ratione temporis, preconditions to exercise jurisdiction. This is one part of the Rome Statute. Also, here I put it again. Well, a triumph for international law. So here's my personal thought on the Rome Statute. Basically, they made a general principle of conducts that are attending to international community. And in some cases, the international criminal law can look again some conducts committed in some countries that were not associated directly with the result of the crime that was charged the criminal in that country, but they can use it as to studies there was a genocide, a war crime, a crime of aggression, and yeah, it's very important that the Rome Statute is still on is still relevant to this day. I think it's a really important law instrument, so they can use it on further stuff. Final thoughts. International criminal law is a really interesting topic. It's a really interesting regime for international law because it works as a subsidiary and complementary instrument to national criminal law instruments and codifications. Some may argue that this can be a threat to the sovereignty of each country and nation. However, as globalization keeps moving forward and there are making no barriers for frontiers, and Interpol and the FBI and the DEA are all working as international instruments to prosecute crimes, there needs to be some binding rules, principles, law to manage that these procedures and utilizations are due with legal certainty and with due process. So yeah, that is my reflection. Was my presentation. My name is Nicolás POSSO, and this was my final exam.